Hello students, your topic for today is procedures and powers of claim tribunal. So we are talking about the motor vehicle act here, and what are the procedures and powers in claim tribunals for this act that is mentioned in section 169. And 169 section is simply it vests the tribunal with powers of civil court for any particular purpose of taking evidence on oath and of enforcing attendance of witness. It was held that it does not exclude either expressly or by necessary implications application of other provisions of code. It also does not restrict inherent powers to secure ends of justice. Oriental Insurance of Company Limited versus Subrata Mitra, this was held in this case. Now, the ambit of the powers of claim tribunal is this, that the tribunal had directed the claimant to bear the expenses of lawyers of opponents while allowing the application for the appointment of commission for examination of doctor. Opponents shall bear their own expenses for going to place of commission for recording evidence. The tribunal had wide powers, but such powers should be exercised by tribunal for doing justice to party. This was held in Kailash Chandra Sharma versus E. Gurunath. Now, the procedure that is to be followed is this, that Section 169 expressly empowers the claim tribunals to formulate its own procedure, since the claim tribunals has all the powers equal to High Court, and it may choose to follow the procedure that is laid down in the CPC. In holding an inquiry under Section 168 of the Act, the Claims Tribunal is empowered to follow such summary procedure as it thinks fit. The intention is this, that the inquiry should not take the shape of elaborate and long drawn proceedings as a regular civil suit, but should be concluded as much speedily as possible. So the nature of inquiry should be more or less like a judicial inquiry, and there can be no gain saying that vast power exists in the claim tribunal to determine its own procedure in dealing with the claim applications. Now, the claim tribunal has all the trappings of a court, and the proceedings before it closely resemble the proceedings in a civil court. The whole intention of the legislature is to ensure a speedy disposal of the claim application that is filed by the injured persons or the legal representatives of the deceased. Then in Krishna Reddy versus Ramalama, and in this case, in case if there is absence of any restraining provisions, the claim tribunal has the liberty to follow any procedure that it may choose to evolve for itself, as long as it is consistent with the rules, as long as it is consistent with the rules of natural justice and it does not contravene the provisions of law. So that is all for today. Thank you so much.